Mr. Clerk, will you call the next case, please?
Yes, Your Honor. In Re Gracelynn H.
Good morning. Good morning. Okay. For the appellant? Yes, sir.
Good morning, Your Honors. May it please the Court, Cameron Hyder on behalf of the appellant. I would reserve 5 minutes for rebuttal. Your Honors, this appeal involves the termination of parental rights. This is a case we have addressed Judge Skelton from Hawkins County's findings at the end of the hearing on termination of parental rights with regard to this matter. What I'd like to focus on today during the oral argument is what I call the fast track that occurred in this case. This child was born early October, went into custody of Department of Children's Services within 4 days. This was in 2023. Thereafter, a CFTM was held. A no contact order was lifted. The state relies heavily on the fact that this mother has a long history of drug abuse. There's no question about that. In fact, during this process, within a few months of the Department of Children's Services taking custody of this child, the mother did relapse and she returned to incarceration for a period of time. But prior to that, she was complying with the services provided by the Department of Children's Services. She was also passing drug screens. There's no question she failed drug screens as well. This is a clear case where we have a drug-addicted mother that this court can take judicial notice of. We see this all the time. But she was making steps towards what the goal was in the permanency plan of reunification. Now, to put this into perspective, the child comes into custody October 9th of 2023. The permanency plan is not created and ratified until December. The mother is then following the services of the Department of Children's Services. Yes, she fails drug screens. She picks up new charges. She returns to incarceration in February of 2024. From February of 2024 to July of 2024, she is incarcerated. The day before she is furloughed to True Purpose Ministries, they have another CFTM with a goal of reunification on July 16th, 2024. Well, here's the catch. On June 10th, 2024, a little over a month earlier, the guardian ad litem files a petition to terminate her parental rights. As I've argued in our brief, where are we in that we do not take the constitutional right to parent so seriously? The Department of Children's Services in this case did not join the petition to terminate parental rights until October of 2024, within the year period, which is standard. This case was so fast-tracked. Now, the judge relied heavily on how the child had bonded with the foster mother and how the family, the foster family, and the child was being nurtured and was flourishing. Of course, this child was. There's no question when we look at the age of this child. But also, we must look at the rights of the parent. The mother in this case, even though she had missteps, she provided opportunity to establish a reunification. And what is so amazing, as I said earlier, is we have a permanency plan that went into effect while the termination petition was pending, and the goal of the permanency plan was reunification with the mother. There's no question the father grossly was absent in this case. But this mother goes to True Purpose Ministries on a furlough. As the court is well aware, the judge took note that this mother wanted to turn her life around. When she went to True Purpose Ministries, she excelled tremendously. All of the reports from True Purpose Ministries said she became a leader in the facility. She was working. She got stable employment, got stable housing. She did everything that the Department of Children's Services asks of the parents that lose custody and guardianship of their children in these types of cases. The whole purpose of a dependency and neglecting proceeding is to reunify the children with their parents. That's the purpose. That's the goal. This court can take judicial notice. We see every day, I see every day, parents who are in termination proceedings that unfortunately go on way too long, a year, 2, 3 years, and they still don't even show up to court. This mother was present. This mother had token 2-hour visits with this child while the termination petition was pending. As I stated in our brief, this should shock the conscience of the court. What have we become to where we're fast-tracking a termination of parental rights case, especially with an infant? We're not talking about an older child.
Let me ask you this question now. This child started out damaged from the very beginning of birth, damaged because of drugs. Then don't you think that might have behooved the mother to, at that point, to make sure that she started out the gate, so to speak, making sure she was doing the right thing?
I think that's an excellent question, and in fact, she did. She did start out of the gate doing the right thing, but she relapsed. And that happens, and I'm not excusing that. I'm not excusing her behavior. I'm not excusing her history. And Your Honor is absolutely correct. The drug exposure at birth, which is a singular incident, a singular episode, I don't excuse that. My client doesn't excuse that. What concerns us is how fast the guardian ad litem moved in this case, to the degree that the Department of Children's Services didn't even join the petition until the year mark after the filing of the petition, or after the removal of the child, rather. So that's our concern today, is that we're looking at a situation where we have a mother who did follow services. Yes, she relapsed. Yes, I went through that whole scenario. But let's just take this into consideration. If the petition to terminate parental rights was not filed until when the Department of Children's Services joined the guardian ad litem's petition, I would argue that it would have been very difficult for them to achieve success on that petition, because by that October, within a year, the mother was successful in all the services and was far exceeding any expectations.
Counsel,
Yes,
excuse
Your
me for interrupting. Could you address the best interest factors in the trial court's findings?
Your Honor, I understand the gravity of best interest, and we are dealing with an infant that had, no question, had and has a very strong bond with the foster family. But as we stated in the brief, we're not asking for an immediate reunification. We have no expectation that this child would have returned to the mother on a particular day without any type of gradual reintroduction process. The child is flourishing as well. The child's doing well. I think where the error lies, though, is how fast this case moved due to the guardian ad litem filing this petition so quickly and so fastidiously. This, at the very least, from our position, should have been transformed into a continual dependency neglect case and possibly a custodial case. Foster parents, as we see every day, are gaining steam to be able to hire their own counsel and pursue custody under the custody statute, because they can prove those statutory factors that are required to establish custody. So I understand the best interest is it's a tall mountain to overcome, but I don't think it X's out the mother's right to parent under the Constitution. If the court has no further questions, that's all I have for now. Thank you
very much.
May it please the court, Mara Cunningham with the Tennessee Attorney General's Office, here on behalf of the Department of Children's Services.
Yes.
defending the Hawkins County Juvenile Court order terminating mother's parental rights. We are here with the goal for establishing permanency for this 2-year-old child whose only home that she has ever known has been with her foster mother. This court should affirm the termination of mother's parental rights because the record supports that the department proved with clear and convincing evidence that there were grounds to terminate mother's parental rights, and that termination is in the child's best interest. Before I move on to grounds, I want to briefly address this fast-tracked issue. The department joined the petition because it was statutorily required to, based on the grounds that were found or alleged. There were Tennessee Code annotated 36-1-113H1 provides statutory requirements for the department to petition or join a petition to terminate a parental rights. 2 of those conditions were present here. So he kept giving the example that we didn't join until a year after the fact, and that the guardian ad litem petitioned after 6 months. Well, one of those conditions is where if there's no progress after 6 months, which was the case that happened here. Mother was in jail whenever the petition was filed and was not furloughed until a month after the petition was filed. So at that point, 2 grounds then existed: wanton disregard and severe child abuse. Which brings me to the grounds. Mother demonstrated a wanton disregard for the child's welfare and committed severe child abuse. Mother committed severe child abuse by continuously abusing drugs while pregnant with the child, despite knowing that she was pregnant with the child and knowing that doing so would be dangerous to the child. This resulted in the child testing positive for methamphetamine and amphetamine and being diagnosed with and suffering symptoms from neonatal abstinence syndrome. Mother also demonstrated a wanton disregard for the child's welfare. She was incarcerated the entirety of the 3 months before the petition was filed, as well as a month after the fact. She was initially arrested in January 2024 for possession of methamphetamines, and then arrested a week later at the hearing for this previous arrest for falsifying a drug test, resisting arrest, assaulting an officer in possession of drug paraphernalia and methamphetamine. This court in Re Audrey S. provides a list of conduct that alone or in combination of constitutes a wanton disregard, multiple of which were present here. Repeated incarceration and criminal behavior based on her substance abuse. Again, mother abused drugs during and after pregnancy, despite knowing that continuing to use drugs during pregnancy would harm the child. And as this court has consistently held, prenatal drug use is a clear wanton disregard for the child's welfare. And then she continued to use drugs after the child was born, despite knowing that doing so would further remove her from the child and cease her visitation. And then continued to use so and was arrested twice, further removing her for the child again. In addition to all this, she did not begin paying child support until 2 months after she was released from jail, over a year into the case, all of which demonstrate a wanton disregard for the child's welfare. Moving on to the best interest factors, the court analyzed each factor, and of the 20 factors found that 10 weighed in favor of termination, 5 weighed against termination, and 5 were neutral. One of those neutral factors, L, we argue should actually be in favor of termination because factor L is DCS reasonable efforts. The court found that this was neutral because mother did not utilize said efforts. However, the ultimate finding was that DCS did make efforts. Mother simply did not utilize them, and she relied on the rehabilitation services instead of DCS. And then the factors that weigh against termination, mother and the child did have a relationship, and she did consistently visit after she was released from jail, so there were about 14 visits. And mother was making progress. However, While these weigh against termination, they should be given little weight because while there was a bond, there was no meaningful bond, certainly not a parental bond between the child and mother. The child cried when leaving her foster mother, cried during the visits, and then once she calmed down, she treated mother just like any other individual that she knew, including the DCS caseworker who supervised the visits. And then she became extra clingy with her foster mother after leaving the visits. And while mother has shown progress and remains sober, and DCS hopes that she continues this progress and furthers, the best interest factors are the child's perspectives, not the mother's. And mother has admitted at trial that she has completed other rehabilitation programs in the past and relapsed, and the only consistency that she has made is while she was incarcerated or in the treatment program. There has been no stability outside of these programs, and this court has found that it is that the child should not have to wait to see if mother can prove this. Again, back to the fast track, he keeps saying that, oh, it's only a year into the child, which again, best interest factors is the child's perspective. It's her entire life. She's over 2 years old now, and foster mother is the only home, the only mother that she knows. Which brings me to the remaining factors weighing heavily in favor of termination. The strength of the parental bond between foster mother and the child. They have a very, very significant parental bond. The child calls her mom. The foster mother brought her home when she was 5 days old from the hospital, stayed up with her through the night while she was suffering from her symptoms from her neonatal abstinence syndrome, where she couldn't sleep because she was in pain. She comforted her. She goes to all her medical appointments. She goes above and beyond and researches extra services so that she can thrive. She also has foster siblings that she is bonded to and grandparents that she is bonded to through the foster mother. So she is really the foster mother is the only mother that this child knows. Contrast this with mother, who has never provided a suitable home for any child, even when she was pregnant with the child. And she is not currently in a suitable home, as the program that she was in was a temporary program, and she had no plans for what she would do after she leaves the program. So there's no evidence of any future stability with mother. And again, any conflicts of best interest is statutorily to be resolved in favor of what's best for the child, not with mother's progress. If there are no further questions, to conclude,
I hear none. Thank you very much.
the state asks that the court affirm the termination of mother's parental rights. Thank you.
Yes, sir, your rebuttal.
Just very briefly, Your Honors, with regard to the foster mother's participation and everything that she has done with regard to the child, there's no question that she's been a lifesaver for this child. But again, we're looking at the constitutional right to parent. That doesn't mean that the mother would be immediately reunified. That doesn't mean that the foster family does not have an opportunity to be involved in this child's life. What it means is we have a situation where the Department of Children's Services, on the record, always stated in the permanency plan that the goal was reunification, even after a petition to terminate parental rights was filed, while my client was incarcerated. If that's not a fast track, if that's not a slap in the face of constitutional rights, I don't know what is. I'd ask that this court reverse and remand for a new trial on the termination of parental rights petition. Thank you.
Thank you, sir. Okay. I want to thank both the attorneys for your presentation. Your case now has been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you both, and you may be excused.